Democrat attorneys general plotted against Trump before he was even elected. A federal judge finds a gun and accessory registration scheme unconstitutional. The White House's fraud task force needs state data. A notary license stripped. And an Illinois politician that's running for 2 offices. Welcome to the States, powered by the Center Square. It's Thursday, August 6th, 2026, and I'm your host, Greg Bishop. Nearly 24 state attorneys general banded together as early as April 2024 to plot litigation against President Donald Trump long before he was reelected to a second non-consecutive term in office. That's according to confidential documents obtained by the Center Square. The document shows nearly half of the state's attorneys general, who are Democrats, signed on to that plan that appears to have the nickname Project for Federal Accountability. Here's more from the Center Square's Enterprise and Investigation Unit.
If he doesn't want to get sued, all he has to do is follow the law.
California Attorney General Rob Bonta says his 82 lawsuits against the Trump administration are apolitical. A former Republican Attorney General says he disagrees, even though he now votes for Democrats.
I, as a Republican Attorney General, decided we needed to sue and challenge Obamacare when it passed the Affordable Care Act and took it to the United States Supreme Court. And then we started to see this shift that no matter, after I left office, I see that no matter what it is, it's going to be a party thing, and the Democrats are going to sue the Republican and vice versa. And it's just horrible. It's a big, huge waste, frankly, of Attorney General time and the good things that you could accomplish together. I left in 2012, early 2013. Just when it was starting to get nasty. But I think some of the greatest work I did and the best friends I had were across party lines.
Look, if I went to court and I said, I'm a Democrat and I don't agree with the Republican administration, can I have an order in my favor? The judge would literally laugh, point to the door, maybe even sanction me and our team, because that's not how the law works. There's no politics in a courtroom.
Now records obtained by the Center Square show a confidential agreement that Bonta signed along with 21 other Democratic attorneys general, planning to sue the Trump administration 9 months before he took office. Were you part of any cases that were planned or involved a document like this? How long in advance was Obamacare, for example?
After it passed, we started talking about it. It's a big selling point now. I get lots of emails from people running for attorney general, lots of texts and emails saying, hey, we got to stop President Trump, or we got to work together as state attorneys general, and that's why you need to give me money, and vice versa. It goes both ways. So it becomes a big, I think, campaign fundraising thing for attorneys general. I don't think that's the best use of attorney general time.
You can read that story with the Center Square's investigative reporters Adam Herbets, TJ Martinell, and Mark Strickers, available now at thecentersquare.com. Meanwhile, a federal judge in Texas has declared that the remaining registration scheme for short-barreled rifles and suppressors in the National Firearm Act is unconstitutional. This is the latest in a series of regulatory issues that have been challenged in the courts, with Second Amendment advocates getting their way. To delve further into this and what it means now and into the future, let's talk with Costas Morris, Director of Legal Research and Education for the Second Amendment Foundation. Costas, thanks for taking time with us. Good to see you again. How significant is this issue about the registration for gun owners?
It's extremely significant, but from the start, I should say that it actually wasn't a Second Amendment win, because although in our case we made a Second Amendment claim, our first argument was on the taxing power, because our argument basically went that when the National Firearms Act was passed, Congress explicitly said this was a tax measure. You had to register your guns only insofar as it was necessary to prove you paid the $200 transfer tax. So when Congress last year eliminated the tax as to suppressors, short barrel rifles, and short barrel shotguns, there was no grounds to keep the registration requirement. You can't, if you're going to base this power on the power to tax, on Congress's power to tax, you can't then also require registration once the tax no longer exists. And the judge agreed with us and struck down the registration scheme on those grounds.
Now, what exactly was involved in that registration? Before, the One Big Beautiful Bill had this, measure that was essentially striking out that fee that gun owners would have to pay if they wanted to register a short-barreled rifle or a short-barreled shotgun or suppressors, which are also known as silencers. What was that process like? They had to give a form to the federal government and then pay the fee?
Yeah, so it was a $200 tax per transfer, and it would essentially be a form that you would fill out, an extra background check in essence. But the biggest burden was, of course, the wait times, because it could take, especially in the pre-digital age, 6 months, a year or more to get these items, these forms approved. So you'd have to wait that whole time before you could get your gun. But even so, even though it has sped up in recent years, thanks to digitization efforts, it would still be an extra registration requirement. And just to be clear, these things are still defined as firearms. So when you go now, even if this ruling is upheld, let's say it's upheld nationwide, you would still need your standard background check when buying these items. You just wouldn't need to register them anymore with the federal government.
And when it goes towards that, initial purchase, you got a background check, but this registration would have required a second background check for that one item.
In essence, yes, it would be a registration, and they would keep a record of it forever that you have this registered. Because remember, again, the point of it originally, at least ostensibly by Congress, was a way to make sure you paid the $200 tax. And the way they did that was through the registration. So again, without that tax existing, there was no reason to have the registration scheme anymore.
Costas, obviously, this is just one district judge, as you hinted at. This could, be something that turns into a national situation. But what is the situation in that district? Is this now on hold for the plaintiffs in this case?
Yeah, so the judge stayed his ruling from the get-go for 7 days to give the federal government a chance to appeal. That's pretty normal. Judges will do that just to preserve the status quo for the time being. But assuming the ruling is upheld, or the stay does not go into effect, or the federal government does not appeal, this ruling would be limited to members of the associational plaintiffs. And although, just to add to this confusion, we're the Second Amendment Foundation and we help pay for this case, but we're actually the plaintiffs in a different case. So our sister organization is a plaintiff in this one. So basically, you want to be a member of our sister org, Citizens Committee, Firearms Policy Coalition, Gun Owners of America, one of those, and you would be you would benefit from this preliminary or this injunction, permanent injunction rather. We do think there's a pretty good chance we'll win this because it is in the Fifth Circuit, and the Fifth Circuit has already expressed skepticism in other contexts about both the taxing power and the federal government's other arguments around the Commerce Clause. From that point, it'll go to the Supreme Court, and we'll just have to see how it plays out.
So still some time before this ruling really kind of spreads across and impacts every gun owner out there that may want a short-barreled rifle or some kind of suppressor. But Costas, if you can, respond to what some of the gun control advocates have had to say about this. You've got Giffords, for example, talking about how it takes away a registration requirement and background check that they say is important to keep bad actors from having these firearms.
Well, look, Giffords, Everytown, all those groups, they predict the sky is going to fall anytime we get a court win, and it never does. They said Bruin would lead to blood in the streets, and instead we have the lowest homicide rate ever. So, no, this is not going to lead to more danger. These sorts of firearms were already very rarely used in crime, almost never. And again, the background check would still exist when you go to buy one. It isn't going to suddenly be a free-for-all on these items. What they want is the registration scheme because it's a future confiscation list, in my opinion. I think that's why they want it. And in fact, Giffords was posting yesterday, I think it was Giffords, about how great this registration requirement is and how it protects us all. And yet in the states they have power over, like California or New York, these items are totally banned. That is their preference. They want total bans, Illinois too, rather than registration. If all they cared about was registration, then why aren't they calling on California and New York and so forth to lift their total bans and just have a registration scheme? So I don't think anyone should take their concerns seriously. You will still need a background check to buy these, and it isn't just going to be a free-for-all. All that goes away is the NFA's burdensome registration requirements.
Well, and then your reaction to, the next thing that they tend to say is this type of thing is just going to enrich the gun industry CEOs.
Well, that's not an argument. I mean, if there was a ruling defending, the right to publish books, nobody would say, oh, this is just going to enrich book publishers. I mean, maybe incidentally, but this is about the Second Amendment rights of individuals. The fact that some people might incidentally profit is not a reason to not respect constitutional rights.
Costas, you've also talked a little bit about Section 926A and some modified rules that the ATF has. That window to make comments has closed. You've got critics like Democrats out of the U.S. Senate saying that the rule is too broad and could create some harms for communities that have stricter gun laws. Your thoughts on that rule concerning somebody traveling interstate with a firearm, as is their Second Amendment right?
Yeah, I was very upset reading that letter from those 4 senators this morning. And it was only 4, which is a little surprising that they couldn't get more to sign on to it. But their argument is basically that the Firearm Owners Protection Act, which was meant to protect firearm owners traveling through hostile states, as long as the guns they were traveling with were locked away out of arm's reach and the guns are legal in their origin state and legal in their destination. They're basically saying if you stop for gas, if you have car trouble and need to replace a tire, if you have a medical emergency and need to go to the hospital, if you have an unexpected layover at an airport, all those things should not be protected and you should be able to be arrested for that stop. That can't have been what Congress meant when they passed the Firearms Owners Protection Act. So we hope that the ATF will not take that comment from those senators seriously and go forward with its proposed rule to protect gun owners while they are lawfully traveling through various states.
Well, Costas, we've got obviously a lot more to talk about in the future, especially as we gear up for what's going to happen at the U.S. Supreme Court concerning bans on certain semi-automatic firearms and magazines over certain capacities. So we'll definitely have to talk with you again in the near future about that case and many others that are happening all across the country. Costas Morris, Director of Legal Research and Education for the Second Amendment Foundation. Greatly appreciate your time. We'll be right back with more.
When we've looked at the anti-fraud efforts that we've taken, one of the weirdest and most difficult parts of this is the black box that exists around certain state programs.
It's Vice President J.D. Vance talking to leaders in Congress about the $230 billion in suspected fraud. Welcome back to the States. I'm Greg Bishop. Now, Vance met with House and Senate Republican leaders to discuss the next steps in the White House Fraud Task Force's efforts to uncover fraudulent payments in federal programs. He said the task force has identified more than $230 billion in fraud over the last several months, but he says Congress needs to help enforce it. He called on leaders to develop legislation that would require data sharing between state and federal government actors, increase the penalties for bad actors, and he said they need to appropriate more funds to help prosecute fraud.
In order to make this really work, we need our colleagues in Congress to really codify some of this stuff, to make sure that it becomes law. And again, this is the sort of thing where, while I see only Republicans surrounding us today, we really have been able to work in some cases with Democratic governors and Democratic attorneys generals on the anti-fraud task force. And we would love, I'm not necessarily holding my breath, but we would love to work with Democrats in Washington to codify some of the anti-fraud actions that we've taken and to take it to the next level.
Now, Vance said data sharing between states and the federal government in those welfare programs is poor. He highlighted federal programs like the Supplemental Nutrition Assistance Program, food subsidies, where non-citizens have received such benefits.
I think the American people would be shocked to learn, because I was certainly shocked when I learned it a few months ago, that when we send tax dollars to the states to administer the STAT program, we have no visibility into who is ultimately getting those benefits. In other words, if the state of California gives those food stamp benefits to an illegal alien, to a violent criminal, the federal government has no visibility, and sometimes the states themselves had no visibility. So we need to work with Congress, and we need some legislation that would actually force some data sharing between the state governments and the federal governments. We need to know where your tax dollars are going, and if the state of California or the state of New York isn't going to tell us, we need Congress to force them to tell us, and I think that's the first and most important thing that we would like to do.
Now, sitting alongside the vice president was Andrew Ferguson, vice chairman of the task force, and he said that federal programs were originally created for a high-trust society. He said almost all of the executive branch agencies are using artificial intelligence to detect fraud in these various federal programs.
Data sharing should be a requirement for participating in these programs because that will unleash the power of American AI ingenuity and innovation in these agencies to stop the fraud before it happens. Because once it goes out the door, it's very difficult to get back. The pay and chase doesn't work. And so the way you stop fraud is you keep Americans' hard-earned money in the agencies unless it's going to someone who actually needs it. And for that, we need data. We need data to make sure fraudsters don't get it, non-citizens don't get it, and the only way for that to happen is if we have data.
Now, Stephen Miller, special advisor to the task force, he said more than 95% of fraud issues could be solved with increased data sharing from states and advances in technology. He called for a federal database that verified age, citizenship, and criminal records for all individuals registering for taxpayer-funded benefit programs. Now, Vance also called on congressional Republicans to increase penalties against individuals who are convicted of defrauding these federal programs. He said fraud crimes are often not prosecuted aggressively, and Miller said most fraud prosecutions under $1 million go unenforced at the federal level, and he said mandatory minimum penalties need to be enforced to deter fraud.
This may be hard to believe that you could steal hundreds of thousands and ultimately millions of dollars and not do any significant jail time. Again, you can look at the sentences for the Feeding Our Futures fraud, which is one of the largest frauds in the history of any country anywhere in Minnesota, to see this. And there's a lot of reasons for that. I think probably the simplest, least conspiratorial explanation is that when Congress was drafting these statutes, they still lived, to use the phrase that he's left in a high-trust society.
Now, Vince Haley, director of the Domestic Policy Council, called on the congressional leadership to source payment systems for fraud and move toward a federal database to verify benefit eligibility. He also called on leaders in Congress to appropriate funds for more fraud investigators. Now, Vance echoed that call for more funding to fight fraud. And while he did not list a specific amount, Vance said the task force needs more aid from Congress to continue prosecuting fraud.
But we need a little bit of resources because while we're saving the American people billions and billions of dollars and we're not spending very much, we need a little bit more appropriated to expand this fraud effort. I think we'll save even more money in the process. It's the sort of investment that, unlike most of the money you guys spend, it never comes back to D.C. Every dollar you give us comes back at least 5 or 10-fold. So it's a good investment, and it's the sort of thing that we need to see happen.
Now, Wednesday's event with the vice president there, it followed news that New York Attorney General Letitia James is leading a group of Democrats suing the Trump administration over a requirement to turn over personal information about Supplemental Nutrition Assistance Program recipients. Now, that lawsuit filed in U.S. District Court Monday. James and 20 other attorneys general, they argue that the Department of Agriculture's recent guidance declaring that some immigrants, including refugees and those granted asylum, are ineligible for SNAP. They say that's illegal. The AGs are asking a judge to block enforcement of that policy. You can get the latest on this and other developing stories at thecentersquare.com. We'll be right back with more. Notarizing signatures of the dead. It's not just something that could be the title of a low-budget zombie movie. It's something that actually happens, regardless of it being fraudulent. And the Center Square investigation into one case down in Georgia, bringing about some accountability. Welcome back to the States. I'm Greg Bishop. The notary public who certified that a Georgia judge's brother signed a will 12 days before his death once certified another signature for that judge's family by a dead woman. After the Center Square started asking questions about her work, Jacqueline Walker has been stripped of her notary license. Joining me to talk about this investigation is the Center Square investigative reporter, Johnny Edwards. Johnny, thanks for taking time with the States. You've been on this story for a while, and for people who don't know the everyday significance of what exactly a notary public does and the importance of them being trustworthy, why does this story matter?
Well, this story matters because this is a new development that calls into question the credibility of someone who signed off on that will. Now, as you mentioned, a DeKalb County judge is at the center of an allegedly forged will case in DeKalb County probate court. Judge Rothelia Stroud, who is both the DeKalb County Magistrate Court judge and the chief judge over the city of Decatur's municipal court, personally filed this will. And shortly thereafter, some other family members alleged that the signature on the will is not the signature of the dead man. The woman who notarized it, the notary public, Jacqueline Walker, has been stripped of her notary commission, not over this will, but because of another document that she notarized for this family 2 years prior. To answer your question, notary publics are commissioned by county clerks of court to sign off on documents, to verify signatures, to verify that the person signing a legal document is actually the person who is signing it. You have to verify that in person with your eyeballs. So this is a pretty important job.
Yeah, anybody who's gone to a bank to have to fill out some forms for a loan or something like that, if you're getting a house, you're going to have a notary public check your ID, make sure it's you sitting right in front of them, and actually sign that document in front of them where they can stamp that with their notary public license stamp. This is a pretty crucial part of ensuring that things aren't fraudulent, right?
Right, absolutely. And again, like I mentioned, it's not that there's been any allegation yet that this notary public did something untoward with this particular will, other than the allegation that the signature, of course, is forged, which is being made by one side in this dispute. This was about a warranty deed that she notarized for the judge's sister-in-law in 2023. Our investigation bore out the niece's allegations on this, which was that her stepmother, the judge's sister-in-law, had been dead for 3 weeks when this notary notarized Carolyn Stroud's signature. Now, interestingly, her husband, who was the same dead man who's on the will, he had gotten a letter from Holiday Inn Vacation Resort saying that if he wanted to unload a timeshare up in the North Georgia mountains, he had 15 days to do it, to file the warranty deed and transfer ownership. I guess he was wanting to be freed of the financial burden of this. So we can only speculate that he might have been under the gun, and he and his wife, or a late wife, co-owned this timeshare. And you can, draw your own conclusions about what might have happened.
And you're talking about, the execution of a will or of property that somebody might have in an estate. And this can get very dicey if the proper documentation is not there. And if you have somebody that's their credibility is being questioned as a notary public, it raises other substantial questions. Talk a little bit more about the people impacted by these allegations.
Well, the impact is that this could have major implications for this court case that's in probate court. Again, this is a different legal document, but it's the same notary public. And this notary public, by the way, is a longtime acquaintance of Judge Rothelia Stroud. This notary went to high school with Judge Stroud and her sister. Judge Stroud represented her in a bankruptcy back in the late 1990s. So, I spoke with two law professors who said this doesn't, close the case or anything, but this definitely is relevant to this dispute over the fact that the same notary public previously for the same family, fudged a document. I mean, she's been stripped of her commission. Now she has a right to appeal this, losing her license. But right now, the Fulton County Clerk of Superior Court has decommissioned her, ordered her to destroy her notary seal.
Johnny, you just mentioned the kind of consequences here of the stripping of that notary license, but have you been able to get any reaction from this former notary at this point?
No, I actually went so far as to drive to her house, which is in south of downtown Atlanta, near the old Braves Stadium. And I knocked on her door. She came to the door and identified myself, introduced myself, and she said she didn't have any comment and closed the door. Now, I've been trying to contact her for months and months about this story because, like I said, she was the notary who notarized that Johnny Stroud did in fact sign this disputed will. So yeah, I mean, I've tried to talk to her. I've tried to talk to Judge Stroud. I've really gotten nothing out of that side of this court dispute other than what I've found in writing through correspondence and letters.
And again, what's fascinating here is she seems to be doing this, at least allegedly, a couple of times for one judge's family. What kinds of questions does that raise for you?
Well, again, she's a longtime acquaintance of the judge. It's alleged in the challenge to the will that was filed in court that neither the notary nor the two witnesses who signed, also saying that Johnny Stroud did in fact sign this will, the person challenging the will, the niece, is saying that they're all longtime acquaintances of the judge and they were not impartial.
Johnny, where do we go from here with this story? Obviously, you've got some litigation that's ongoing. Just how do you think this investigation that you've done there in Georgia is going to further impact that?
Well, it's already had some impact because when I started looking into this, the notary had not been decommissioned. That happened, as I was working on this story. The first time I called the clerk of court, she said that she wasn't going to investigate this or do anything unless the niece who complained filed a police report. In the course of my reporting, the niece went ahead and did that and filed the police report, and so the decommissioning happened. But there's a lot of different places this is going to go. There's a hearing scheduled later this month, August 27th, in this case. Finally, this case sat in limbo for quite a while because every judge in DeKalb County had to recuse themselves because Rothelia Stroud is a DeKalb County judge. I think they finally appointed it to a judge over in Fulton County, and there's finally a hearing scheduled. So that's some movement. Also, Jacqueline Walker, the notary, has the right to appeal having her license stripped. I believe she has 10 days from receipt of the letter to do that. So we'll be watching to see if she does in fact appeal, and we'll be attending that public hearing if she does.
Looking forward to that update when we can find it. It's an important story about, holding people accountable for these types of accusations, because as we're hearing, it can have these pretty significant ripple effects, impacting families, impacting individuals, impacting the transfer of property, and a whole host of other things. So, Johnny Edwards, greatly appreciate your time. Be sure to get his work at thecentersquare.com. We'll be right back with more from the States.
far too long, auto insurance companies have operated with little to no oversight, giving them free rein to raise rates and leaving consumers without any real recourse. In 1 year alone, Illinois drivers were hit with an average 18% increase in auto insurance premiums. Again, in a single year, even for those with spotless driving records, one of the steepest increases in America.
That's Illinois Secretary of State Alexi Giannoulias this week, standing alongside Governor J.B. Pritzker, who signed insurance regulations. But Giannoulias is making headlines not just for wanting to regulate auto and home insurance companies. He's also making headlines for running for two offices at the same time. The one he currently holds as the Secretary of State, and then also Chicago Mayor. Welcome back to the States. I'm Greg Bishop. Now, 2 days after Secretary of State Alexi Giannoulias announced a bid for Chicago Mayor, he joined the governor at that signing ceremony for two insurance-related bills after he said his support wasn't political. Now, the bills also, they allow the Illinois Department of Insurance to regulate and review insurance companies over proposed policy rate hikes for homeowner and auto insurance. Now, Pritzker, he said the bills are not out of the ordinary and are necessary to provide fairness and accountability for Illinois residents.
With my signature today, Illinois will begin requiring insurers to transparently justify proposed rate increases, and we are empowering regulators to fight unfair and arbitrary hikes. This new law prohibits companies from charging premiums that are deemed excessive or with terms that are inadequate or unfairly discriminatory. It protects Illinois residents from being burdened with costs from losses that occurred somewhere else in the country, not in Illinois. Most importantly, Illinois regulators now have the tools to enforce those common sense principles, with the power to object to rate increases so consumers won't be left holding the bag. This isn't some radical proposal. It is authority that regulators in every other state in the country have exercised for years.
Now, while officials argue that the law will provide affordability, industry groups with the insurance industry, they have said that the laws will have an inverse effect. The Illinois Insurance Association, the American Property Casualty Insurance Association, and the National Association of Mutual Insurance Companies released a joint statement after Tuesday's signing. They said this shift will make it harder for insurers to respond in real time to market conditions and adjust rates up or down based on actual claims experience. Now, the governor, he pushed back and contended that that is just not the case.
There aren't any additional costs, to be frank. Nobody's getting closed down. Nobody's saying that they can't raise rates if there is a need. They're already producing the information that's required if they truly need to raise rates because they can't cover those costs with the premiums that they charge. Then, I guess what I'm saying is it's silly to suggest that this is going to raise rates.
Now, Janulius, he said the cost of auto insurance rates being raised without oversight while insurance is mandatory for drivers is unfair. And he said 48 other states regulate insurers this way.
Today, Illinois joins 48 other states by giving regulators meaningful authority to review rate filings, challenge excessive or unjustified increases, and require rebates when customers are overcharged. Illinois drivers finally have a watchdog with real teeth, not one forced to simply accept whatever insurance companies submit.
Now, both of these insurance laws, they take effect July 1st. And while Janulius heralded the new laws, he continues mounting his campaign for another job. Janulius launched his campaign ads over the weekend for the job of Chicago mayor, which that election's coming up February 23rd, in a pretty large field of candidates tossing their hats into the ring. Now, that February 23rd election would come after the November 3rd election, where Janulius is vying for another job as the Illinois Secretary of State to get another term in that 4-year term office. Now, Illinois Comptroller Susana Mendoza, she announced her plans to run for Chicago mayor back in June, but that was months after she said she would not seek re-election to the statewide office of comptroller. Now, Mendoza said it's not super ethical for Janulius to ask almost 13 million people to support him for Secretary of State while he's seeking another job. She told the Center Square that she's all in for Chicago. Alexei, quote, is clearly all in for Alexei, and that's why he's hedging his bets and he's running for both offices. She said Chicago deserves a mayor who's all in. Now, Mendoza, a Democrat, said although Janulius asked to be judged on his record as Secretary of State, he should also be judged on his time as state treasurer. She said that he was responsible for overseeing the Bright Start College Savings Plan, where the office lost $100 million in college kids' funds. Mendoza also went on to recall Janulius' time at Broadway Bank, which was seized by federal authorities in 2010 after allegations that the bank was linked to organized crime figures. Republican Secretary of State candidate Diane Harris said Janulius is hollowing out his political government staff to populate his campaign office. She said it becomes an election engineering, and that's what it becomes because you're campaigning on the particular company time. And in this case, the company time is government time. She went on to tell the Center Square that Janulius should withdraw from the statewide election in November if he's planning to run for mayor next year. She said, quote, if he is elected there, he would only serve a few months as Secretary of State. And I'm sure that would not be what the voters would be voting him for. If Janulius is elected mayor, the Illinois governor would be the one tasked with appointing his successor as Secretary of State. And at this week's bill signing with Janulius behind him, Governor J.B. Pritzker was asked about the growing number of people jumping into the race for Chicago mayor.
People want to see, they want to see a Chicago that really works for everybody. And so I think there are people who feel strongly, like I do, about public service and put themselves forward. Look, I can tell you this, I am going to work with whoever it is. I'm going to work with whoever it is that becomes the next mayor. As you know, I've had 3 mayors so far as governor. Then I've worked with all 3 of them in various ways. So I'm going to make sure that I have the opportunity to work with whoever it is that becomes the next mayor.
This coming from the Illinois governor, who many have suspected is vying for the White House in 2028, which would come 2 years into the next term for Governor J.B. Pritzker if he was to be elected in November. We'll be keeping a close eye on that. And also the race for Chicago mayor, where incumbent Chicago Mayor Brandon Johnson is expected to also run alongside a slew of other candidates. Stay up to date with that and other stories at thecentersquare.com. We'll be right back with more from the States. Welcome back to the States. Now it's time for America's Talking, with headlines from across the country that you can find in the description below or in your inbox with the Center Square newsletter, free at thecentersquare.com. More than 600,000 voter files in Arizona's largest county were hacked before the 2020 elections, with prosecutors refusing to pursue charges according to declassified documents released Thursday. The Center Square, Washington, D.C. Bureau Chief Sarah Roderick Fitch reports the case stems from a 2020 Maricopa County voter registration site where a suspected hacker exploited the county's voter records by illegally extracting 633,000 records, including 930 with sensitive information. Following this incident, the FBI thoroughly investigated, handing over the information to the U.S. Attorney's Office for that district of Arizona, the Arizona Attorney General's Office, the Maricopa County, Arizona Attorney's Office, and the Pinal County, Arizona Attorney's Office. But all declined to prosecute that case, leading to it being closed in 2023. Now, the suspect, who authorities said confessed, claimed to have discovered the vulnerability on Maricopa County's voter registration record servers using a PowerShell script to extract that data and store it at his home. However, he destroyed the files before an FBI raid. Wealthy households scrambling to avoid New York City's new second home tax, with thousands seeking an exemption from the Mamdani administration. The Center Square contributor Chris Wade reports nearly 5,000 property owners have begun the process of applying for an exemption to the pied-à-terre tax, according to the city's Department of Finance, while about 2,000 property owners have submitted their applications. An estimated 17,000 homeowners may be subject to that tax. The new levy was approved by New York Governor Kathy Hochul and lawmakers as part of New York City's bailout and calls for charging eligible property owners a 4% surtax on 1 to 3 family second homes valued over $5 million, and on co-ops and condos valued at $1 million. To obtain an exemption, property owners must prove that their home in New York City is their primary residence. They'll also be required to show identification, such as a driver's license, utility bills, their most recent federal and state tax returns, a mortgage or lease agreements, and other documentation to get that exemption. And that must be completed by September 18th, according to the city. New York City Mayor Mamdani, he said the new tax is expected to drum up $500 million in annual revenue, and others arguing it'll force some New Yorkers who are able to move out of the city to find lower taxes. The American Civil Liberties Union of Nevada suing the Las Vegas Metropolitan Police Department over what it called excessive fees on public records requests. The Center Square contributor Liam Hibbert reports that the lawsuit was filed by the ACLU along with two news organizations with a local law firm last week. Now, the legal action alleges that the LVMPD violated the Nevada Public Records Act by purposefully overcharging for access to public records. According to the ACLU, the high cost of public records requests is a purposeful violation of public records law, which they argue keeps public information out of the reach for regular citizens. The Las Vegas Metropolitan Police Department asked for more than $6,800 for June 2025 ACLU public records requests for body camera footage, according to the lawsuit. The Nevada Public Record Act was designed to give the public quick access to government records within the law to foster democratic principles, according to the document. Now, under the Public Records Act, Nevada government agencies cannot charge more than the minimal fee for obtaining public records. And the Assembly Republican Caucus in California's State House had an abrupt change in leadership this week after former Assembly Minority Leader Heath Flora was suddenly dismissed from his role in favor of Assembly member Alexandra Macedo. Other Republican Assembly members were elected to roles in leadership for the Assembly Republican Caucus, including Assemblymember David Tangipa and Assembly Minority Whip. Assemblymember Josh Hoover was elected Minority Floor Leader. Now, Hoover telling the Center Square's Madeline Shannon Wednesday that he thought Flora, who held the position as Assembly member Minority Leader for almost a year, did a fantastic job leading the caucus. He said, it was always the plan that it was going to happen at some point this year, and he thought that he's ready to get to work with the new team on moving the caucus forward in the California legislature. Now, according to the New York Post, Flora frustrated other Republican politicians in the California state legislature this year after voting in favor of increasing sales taxes. He then became the target of two ethics investigations over his alleged misuse of campaign funds and behested payments. And that's just some of what America is talking about. You can get these and other headlines at thecentersquare.com. From my studios in Central Illinois, I'm Greg Bishop, and join us here Friday for more stories impacting you, the taxpayer, from all across the country, only with the states, powered by the Center Square.